Reading. All right, sorry everybody. Oh my goodness gracious. Oh my goodness gracious. I'm so sorry. I'm so sorry about that. Oh my gosh, I feel so bad about our interruption there. We were doing great. Then we had a moment. I'm so sorry. I'm so sorry about that. That's one of the oh my gosh, I'm so sorry. That's one of the things, everyone, when I'm actually going live, it's really hard for me to see what's on the screen. I'm so sorry. Once he's a guest. Yeah. I got it. Thank you so much. Oh my gosh, it was my mistake. I just couldn't see the button. And so I pulled him in and then I don't think he understood. Oh my gosh. All right. Yeah, if anybody comes and tries to hop in, you can just, block away. I apologize, everybody. I think we all needed a moment because I'm like, boy, this Bove guy is kind of a jerk. So I told Amanda's mom, that's so funny. It's happened to a few creators lately. I guess there's some kind of thing going on, but yeah, again, I have to apologize, everybody. My vision is not great, and unfortunately, when I'm in a live, I have a really hard time seeing the screen, so I get a little frustrated. My Hulk was about to come out, but luckily it didn't. Yes, it's really weird. Yeah, that was really weird. So I apologize, everybody. We've kind of thrown off the move here. But we'll just keep going forward and no apology necessary. Oh my gosh. All evening I've been hitting the right side of it, but for some reason I couldn't do it. Oh my gosh. I couldn't see. Yeah, I know, right? I had no idea. Here's speaking till Terry appeared. Yeah. That's all right. I needed to yell at somebody and I kept trying to tell him to leave. So that was something else. I had to use my stern tone. I was trying though. I'm like, don't scare the chat. Oh my goodness. Oh my goodness gracious. Oh, that's so funny. I apologize, but there we go. Commercial break. Yes. All right. So let me, I got to go get some Tang. We'll just go forward. Yeah, it seemed like none of the buttons were working. I'm like, what the H just happened here? All right. I may cut that part out when I post this to YouTube. We'll see. We needed a break. That guy. Oh my gosh. Oh my goodness. All right, everybody. All right, here we go. We're back in it to win it, everyone. Back to our regular programming. Maybe something stronger. I know. My family members have all come out and they're like, what just happened? It's all right. We're back on. Oh my gosh. Yeah, see, I just can't see the screen well enough to do any of that kind of stuff. Oh my gosh. All right. Here we go. Let's get back into it because we're here for justice. Oh my gosh. All right. Where were we now? Oh my goodness. Oh my goodness gracious. Back to sleep. Atticus is looking at me. Oh my gosh. All right. Here we go. Back into it. So I think at this point I was saying, wow, and humiliation, rude, and not allowing them to go back to do any kind of work. And that's pretty awful here. So let me reread this sentence and we'll just dive right back in, everyone. Oh my goodness gracious. Oh, it lightened the mood. I know. That guy's probably like, oh my gosh, what happened? Too bad. I told him to stop. While the AUSAs are in an off-duty status, they are not to use their government-issued laptop, phone, and ID badge, PIV card to access duty stations or any other federal facility unless explicitly directed to do so. While on administrative leave, if contacted by management, the AUSAs must respond by phone or email no later than the close of business the following business day. So at this point, what we have is, a micromanagement situation by a jerk. So, yeah, this level, he didn't speak English. Oh, yeah, I don't know. I mean, I was like, whatever. Without issue, I know, right, Sarah? How are they supposed to know the email address? So this is huge. Again, we've got U.S. attorneys all around the United States, right? And these just are the U.S. attorneys in New York. And so they're saying here, like in New York, they're very specific. You got 24 hours. He's basically bring Hawk in next time. I will. I hate that. This is really bad. Yeah, this is really bad. So beware. All right. Here we go. We got to make up some time in the air here. Oh, my goodness. Oh, my goodness. All right. Here we go. Oh, that's so funny. The conclusion of these investigations, the Attorney General will determine whether termination or some other action is appropriate. So he's saying, look, I'm going to fire your people. Based on attendance at our recent meetings, I understand, well, again, this is a dig, I understand the relevant AUSAs to be Hagen Scotton and Derek Wickstrom. Now, as we know, Mr. Scotton here, oh my God, seriously? Oh my gosh, he's here. He's coming back. All right, moderators, can you block him for me? Block, 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 block. I don't. Oh my gosh, everyone. All right. Pray for me right now. Pray for me. Okay. Here we go. Block him, block him, block him. All right. So, again, we know we've got this resignation letter that was put in here by Hagen Scotton. And so I will be reading that. Turn your invites off. Yeah, I thought I had them off. Hold on here, everybody. Let's just take care of the business. Da 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 da. Yeah, I mean it's already off, man. Oh my goodness gracious. Okay, yep. All right. We should be good now. He's in love. I don't know. I don't know about that. Oh my gosh. And we will be reading that next. I know, everyone. Get your popcorn. That would be a popcorn moment. All right. If either of these AUSAs wished to comply with my directive but was prohibited from doing so by you or the management of your office, or if these AUSAs wish to make me aware of other mitigating considerations they believe are relevant, they can contact my office directly. Yikes. The Justice Management Division and EOUSA have taken steps to remove access to electronic devices. And I ask that you and the AUSAs cooperate with those efforts and preserve all electronic and hard copy records relating to this matter, whether they are stored on official or personal devices. Wow, this is so bad. Did I turn them off? Yay, thanks, Sarah. This is really bad. This is a complete power trip from some guy that's got an ego that's too big. Third, under your leadership, the office has demonstrated itself to be incapable of fairly and impartially reviewing the circumstances of this prosecution. My gosh, this guy's like such a jerk. Yeah. I agree, Vicky. I agree completely with you. And, this is some serious alarm bells going on here with this dude. Wow. Therefore, the prosecution of Mayor Adams is transferred to the Justice Department, which will file a motion to dismiss the charges pursuant to Rule 48 of the Federal Rules of Criminal Procedure. My prior directive regarding no further targeting of Mayor Adams or additional investigative steps related to this matter remains in place. Yikes. Yeah, he's way, way out of line here. And I know as attorneys, we fight each other all the time, but we also have a level of professional respect to each other that's required by the rules. Background: on January 20th of 2025, the Executive Order 14147, Trump established the following policy, quote, "It is the policy of the United States to identify and take appropriate action to correct past misconduct by the federal government related to the weaponization of law enforcement." In a February 5th of 2025 memorandum setting forth the department's general policy regarding zealous advocacy on behalf of the United States, the Attorney General stated, "Any attorney who, because of their personal political views or judgment, declines to sign a brief or appear in court, refuses to advance good faith arguments on behalf of the administration, or otherwise delays or impedes the department's mission will be subject to discipline and potential termination consistent with applicable law." All right, so, oh my gosh, everyone, this is really bad. This is really bad. This is a really bad situation here. Your office was not exempted from the president's policy or the attorney general's memorandum. That's just being rude. On February 10th, I directed you to dismiss the prosecution of Mayor Adams based on well-founded concerns regarding weaponization, election interference. Wait, that wasn't listed. And the impediments that the case has imposed on Mayor Adams' ability to govern and cooperate with federal law enforcement to keep New York City safe. Oh my gosh, my February 10th memorandum indicated that I acted pursuant to the authorization of the Attorney General because she's kind of a dumbass. The mechanism for seeking dismissal is Rule 48 through the Federal Rules of Criminal Procedure. Note 2 of Rule 48 explains that the rule confers the power to file a dismissal by leave of court on the Attorney General, as well as on the United States Attorney, since under existing law, the Attorney General exercises general superintendence and direction over United States attorneys. This is really bad. I was going to read this out loud. Oh my gosh. Oh my gosh. This is so bad, dude. This is really bad. This is a really bad one. All right, I'm not trying to scare anybody, but this is really bad. Yikes. So here, let's move to the next page. We've got page 2. All functions of other officers of the Department of Justice and all functions of agencies and employees of the Department of Justice are vested in the Attorney General. Prior to issuing the February 10th, 2025 memorandum, I reviewed public filings in this matter and your office's prosecution memorandum and classified submissions. I met with you and the prosecution team. Held a separate meeting that involved you, the prosecution team, and the defense counsel, and then met with you privately in my office. So this is where the meeting was when he said that the notes had to be destroyed, right? And then we've got footnote number 3. You correctly noted in your letter to Attorney General that during the second meeting, I questioned why a member of the prosecution team appeared to have brought for the sole purpose of transcribing our discussion. You failed to note, however, that I made those comments in the context of a conversation about leaks relating to our deliberations. I don't think that really matters. My goodness. During those meetings, I invited written submissions from both sides, and how generous. And I carefully reviewed those submissions. Thus, your recent suggestions about a lack of process around the Justice Department's decision are not grounded in reality. And this is, again, another rude piece. You have not complied with the clear directives in my February 10th memorandum. Further, you made clear that you did not intend to do so during telephone calls with myself and Chad Mazzell, the Attorney General's Chief of Staff, on February 11th, as well as in written submission to the Attorney General that day. You also stated that the prosecution team had reviewed your letter to the Attorney General and that they would not file a motion to dismiss the case. At approximately 1:50 p.m. today, you tendered your resignation via email. Oh my gosh. This is so bad, everybody. This is so bad. My anxiety's through the roof. I know. Oops, sorry. I'm trying to make it so it doesn't fuzz out. Number 2, discussion. The weaponization finding in my February 10th of 2025 memorandum. So even this language, the weaponization finding, like who is he to find weaponization, right? Like we already talked about this. You have to have a legal reason for a dismissal, and his opinion of political motivations is not a legally justifiable reason to dismiss a case. Memorandum was made pursuant to a policy set forth by President Trump, who's the only elected official in the executive branch, in connection with a decision that was authorized by the Senate-confirmed Attorney General of the United States. So this is another situation where he's trying to kind of puff up and say, I have the ultimate power and authority, and entirely consistent with guidance issued by the Attorney General shortly after that confirmation. I don't think she knows what she's doing. Your office has no authority to contest the weaponization finding. This is a huge, huge red flag, everybody. All right, this is huge. So all it takes in order to make a decision for prosecutorial discretion is that you have to ask BOV if it's weaponizing the Department of Justice or not. So you have one man here, along with the Attorney General, again, right? We look at the piece. We have two people, the Attorney General and the Deputy Attorney General, and they are the ones that are determining the weaponization, and so it's up to them. So we have pulled out the actual process of criminal justice here, and we have inserted this guy thinking that he's the one that gets to do the finding, and he wrote it down on paper. Oh my gosh. Or the second independent basis requiring dismissal set forth in my memorandum. Wow. The Justice Department will not tolerate the insubordination and apparent misconduct reflected in the approach that you and your office have taken in this matter. I mean, this is like, what you hear in the Indiana Jones movies, right? Before his face gets like fried off. Oh my gosh. Improper weaponization. So let's look and see what his standard is. All right. So he's setting the standard. He's saying, I get to determine weaponization. It's not about you, your experience, or a legal reason. I'm the one that gets to determine it. So let's see how he's determining it. You are well aware of the department's weaponization concerns regarding the handling of the investigation and prosecution of Mayor Adams. Those concerns include behavior that supports, at minimum, unacceptable appearances of impropriety and the politicalization of your office. So if he's setting a legal standard, he certainly doesn't have the authority to do that. The investigation was accelerated after Mayor Adams publicly criticized President Biden's failed immigration policies and led by a former U.S. attorney with deep connections to the former, oh my gosh, to the former Attorney General who oversaw the weaponization of the Justice Department. So he's actually getting into the facts of the case. And that's another problem here too, everybody, right? Because it's our juries that determine what the facts are. They're our fact finders. So he's making some fact determinations, and he's not, a juror or a judge, but he's coming in and saying, without reviewing the file, without looking at the case, I'm making determinations of fact. And that's not his role. If the drop charges was for a reason, this would have been a 2-sentence letter. Exactly right. That's completely correct. We talked about that too. There can be legitimate prosecutorial conduct reasons why you would ask for dismissal. Absolutely. And that happens, every day. But there isn't. So he's become the fact finder here, which is not his role. Based on my review and our meetings, the charging decision was rushed as the 2024 presidential election approached. And as the former U.S. attorney appears to have been pursuing potential political appointments in the event Kamala Harris won that election. Again, all right. After President Trump won the election in late December of 2024, the former U.S. attorney launched a personal website which closely resembles a campaign website of relevance that touts articles about the ongoing prosecution of Mayor Adams with titles such as, quote, U.S. Attorney Damian Williams has come for the Kings, and quote, a mayor, a rapper, a senator, a billionaire, meet the man who has prosecuted them all, end quote, and quote, federal prosecutor Damian Williams flexes power against Eric Adams and Sean Combs. Okay, the former U.S. attorney's, hashtag freedom of the press, whatever. The former U.S. attorney increased the appearances of impropriety by releasing an op-ed, which I've been showing you here. This is the op-ed here. entitled, quote, "An Indictment of the Sad State of New York Government." By the way, he had already resigned from his position at the time, and it's an opinion piece. It certainly isn't anything other than his own personal opinion. So, woman who resigned was in the Federalist Society, clerk for Scalia. Oh my gosh, I know. And I was thinking too, if she clerked for Scalia, I'm sure she, the chief knows her, Alito knows her, Thomas knows her, Sotomayor would have all had contact with her. In that piece, he disparaged Mayor Adams with the following comment, quote, "America's most vital city is being led with a broken ethical compass, end quote. The former U.S. attorney also made what I reasonably interpreted as a reference to himself in that piece, where he suggested that there was a need for elected officials willing to disrupt the status quo. So again, he's going into an op-ed and saying because of what a former prosecutor who resigned said in an opinion piece in the media that that was improper indictment charges, which had occurred months before any of this happened. Defamations? Good question. You did not directly defend the former U.S. attorney's behavior in response to a recent defense motion, nor could you. That's all right. His actions inappropriately politicized and tainted your office's prosecution potentially permanently. Instead of addressing these concerns with the district court, you simply claimed these actions were beside the point or, irrelevant. Not true. The actions by the former U.S. attorney implicate the concerns that President Trump raised in Executive Order 14147 in connection with the prosecution of an elected official who voiced opposition to the prior administration's policies. The fact that the district court denied the defense motion does not establish that continuing the prosecution of Mayor Adams reflects an appropriate exercise of prosecutorial discretion. Similarly, the fact that a U.S. aide convinced a grand jury to return an indictment based on a one-side... Oh my gosh, is he going after our juries, everybody? Is he going after our juries as a deputy attorney general? Oh my gosh. All right, let's go through this again. Similarly, the fact that a U.S. aide convinced... So again, those are our prosecutors convinced a grand jury to return an indictment based on a one-sided and inherently partial presentation of the evidence does not establish that the case was appropriate at the time, much less that it would be appropriate to continue to pursue the case based on the events that occurred after the true bill was returned. Holy crap box, everybody. Holy crap box. Oh my gosh, this is really bad. So he's coming in and saying, basically, grand juries can indict a ham sandwich. And he's like the second most powerful attorney in the United States when it comes to criminal cases. Are you flipping kidding me? This is crazy town. We are in crazy town. We're in Crazyville, everybody. This is bad. The ministry is, oh my goodness gracious. This, oh my gosh. All right. Sorry, everybody. I need to calm down. Let me take a drink. Let me take some tea. Let's calm down. So this is the most dangerous thing I've heard him say so far. Didn't he say he didn't consider any of the evidence before spending time on the first? Yes, he did. He said he hasn't looked at any of the evidence or the case. And here he's saying the grand jury process is basically rigged, is what he's saying. That grand juries don't work. Can you even believe it? I can't believe it. I am shocked. I'm in a stage of shock. I'm trying to come back. Oh my God. What? All right. So this is an impeachment moment. This is impeachment here. This Bondi lady, whomever she is, she pre-approved. Oh, thank you so much. Oh, Shadow, you're so generous. I appreciate it. This Bondi lady, who clearly doesn't know what the H is going on, if she approved this, what I'm reading right now, this is impeachable right here. This is an impeachable constitutional violation, I would say right here. Oh my gosh. Oh my goodness. I want to get on a plane and go smack some people. That's not right. So what recourse do we have? We have to wait. I mean, this just came out yesterday. Seriously, this Mohib guy's back again, everybody. How did this happen? I thought I declined it. Oh my gosh. And now I got some guy from Pakistan coming and harassing me. Seriously, dude, stop it. Oh my gosh, trying to discredit the judiciary. Well, the biggest problem here is that this Bovey guy really thinks he is something special. He really does. Like, what kind of an attorney general position would come in and say grand juries are tainted? No one would, because they are the foundation of our entire criminal justice process. So you can say this all you want when you're talking to Tucker Carlson, but you can't just put this in a memo and then give it to somebody who resigned. Oh my gosh, this is a lot. This is a lot, everybody. It's a lot. All right, let's keep going. I'm sorry, my vision blurred for a minute. Yikes. Red flag alert, yes. The Justice Department will not ignore the fact that the timing of charges authorized by a former U.S. attorney with apparent political aspirations interferes with Mayor Adams' ability to run a campaign in the 2025 election. This man is digging himself a hole. He is just confessing, setting out how he is so wrong here and how he is behaving unethically. So, I mean, there's that. That's nice. Like, he's writing out a confession here. Your reference to the schedule underlying the prosecution of Senator Robert Menendez is not in any way persuasive in light of the evidence handling issues that arose in connection with that trial. What does that even mean? Because he's not raised any Fourth Amendment questions here. He could have used that as a reason to dismiss this case, but he didn't. If anything, that experience counsels in favor of more caution in these matters, not less. But the record does not reflect such caution. But he already told us he didn't read the record. He didn't read the case. He's like, I'm not looking at the case. I'm just doing what I want here. In October of 2024, a prosecutor responsible for the prosecution of Mayor Adams represented that the first batch of discovery in the case included about 560 gigabytes of data. Thus, as a trial date was negotiated, Mayor Adams was faced with the impossible choice between seeking to defend himself at a pre-election trial in the hopes that he could campaign based on exoneration. This is exactly what he wrote in Trump's brief. This is exactly what he wrote in the DC case, where he said Trump's not going to have time to answer all this stuff because he's running. This is the same argument. I'm wondering if he cut and pasted it. Oh my gosh, it's a lot, everybody. All right. All right. So I cannot seem to get rid of that guy. He's still following me. That's all right. I know the buttons now. So here we go. And taking a reasonable amount of time to review the discovery and prepare his defense. Does this sound familiar, everybody? Also in the Florida case, he's like, yo, look at all this stuff. I want to have time to look at it. At a post-election trial, his acquiescence in the former option does not justify your office's decision. Wow. So just 1 minute, everybody. I thought I had turned off. Hold on here. Oh, my goodness. Oh my goodness. How is this even happening? I thought I turned everything off. No, it looks like, all right, well, tag him in the comments. We can't get rid of him. Come on, man. All right, hold on. Here we go. I have we put everything into place that I possibly can. Okay. There we go. All right. I've redone it. I can't see to block him. Fingers crossed, everybody. All right. Here we go. Diving back in. In your letter to the Attorney General, you made the dubious choice. Wow. To invoke Justice Scalia. I would say, too, this reminds me of a lot of the filings. The account's private. The mods can't see them. Fair enough. I've got a couple more things that I've just clicked off, so maybe that'll work. Right, to invoke Justice Scalia. As you are likely aware from your professional experience, Justice Scalia fully understood the risks of weaponization in lawfare. This is just rude. Nothing is so politically effective as as the ability to charge that one's opponent and his associates are not merely wrong-headed, naive, ineffective, but in all probability crooks. And nothing so effectively gives an appearance of validity to such charges as a Justice Department investigation and even better prosecution. And citing the Morrison case, while the former U.S. attorney is not a special counsel, Justice Scalia's Morrison dissent aptly summarized the department's weaponization concerns here. Note it was a dissent. Let's just put that in there. All right, that was Scalia's dissent. There's also great irony in your invocation of the famous speech by former Attorney General Robert Jackson. God, he's being so rude. His remarks are unquestionably relevant here, but not in the way you have suggested. Jackson warned that some measure of centralized control over federal prosecutors was necessary. The senior leadership in the Justice Department exercises that control. Moreover, one of Jackson's concerns was the most dangerous power of the prosecutor arises from the risk that the prosecutor would pick people he thinks he should get rather than pick cases that need to be prosecuted. So again, what she had said in her letter was she didn't say prosecutors don't screw up or don't have negative intentions or are unethical. What she's saying is, in this case, with these facts, that is not what's happening here. It is in this realm in which a prosecutor picks some person whom he dislikes or desires to embarrass that the greatest danger of abuse of prosecuting power lies. It is here that law enforcement becomes personal and the real crime becomes that of being unpopular with the predominant or governing group, being attached to the wrong political views, or being personally obnoxious to or in the way of the prosecutor himself. I think that there's something wrong with this attorney. I think there's something wrong with him. I really do. There's something not right here. Regardless of how the investigation of Mayor Adams was initiated, by 2024, your office's work on the case was extremely problematic in that regard. Finally, your suggestion that President Trump should issue a pardon to Mayor Adams reveals your office's insubordination is little more than a preference to avoid a duty that you regard as unpleasant and politically inconvenient. Your oath to uphold the Constitution does not permit you to substitute your policy judgment for that of the president or senior leadership of the Justice Department. All right, everybody, we're back in the schmatzy land. Oh my gosh, everybody, this is really, really out of control. This is really out of control here. Oh my gosh, and you are in no position to suggest the president exercise his exclusive Article 2 authority to make your job easier. Did Stephen Miller write this? Was he summoned? Did someone put a circle together and summon him? This sounds like Stephen Miller to me. This sounds like Stephen Miller. I mean, this Bovee guy isn't particularly bright, but this language here, this is the language of the schmatzis. Yeah, we're in schmatzy land here. Because she dared to quit instead of... Exactly. All right, so, oh my gosh. All right, red flags, everybody. Red flags here. Red flags. Wow. All right. Oh my goodness. All right, we're coming down to the end. Thank goodness, because, I'm getting scared. For all these reasons, dismissal is necessary in the interests of justice. Your refusal to recognize that fact and comply with my directive has only exacerbated the concerns I raised initially. Oh my gosh. I think this is like, oh my gosh. Where are we? We're in 1933. Let's just see what year we're in here. This is really scary stuff, everybody. B, interference with Mayor Adams' ability to govern. Your objections to the second basis for my February 10th directive that the pending prosecution has unduly restricted Mayor Adams' ability to devote full attention and resources to illegal immigration and violent crime are based on exaggerated claims that further illustrate your office's inability to grapple with the problem that this case actually presents. Holy crap. Oh, wow. Wow, this is, oh my gosh. As a result of pending prosecution, Mayor Adams is unable to communicate directly and candidly with city officials. He's responsible for managing, as well as federal agencies, trying to protect the public from national security threats and violent crime. Wow, I'm worried now. If Adams actually gets that security clearance back, wow. Wow. I mean, it sounds like they've got an inside person with Adams at this point. That's really dangerous. Mayor Adams has been denied a security clearance that limits his access to details of national security issues. Thank goodness. In the city he was elected to govern and protect. He cannot speak to federal office officials regarding imminent security threats to the city. He cannot fully cooperate with the federal government in the manner he deems appropriate. Oh my gosh. Oh my gosh, to keep the city and its residents safe. This situation's unacceptable and directly endangers the lives of millions of New Yorkers. So that's what he's saying. He's PO'd because Adams doesn't have security clearance in order to do what they want to do with the immigration stuff. My directive to you reflected a determination by the Justice Department that these public safety risks greatly outweigh any interest you have identified. So it's more important than the immigration is more important than following the actual criminal laws and procedures. So that's, again, that's a red flag here. That's another red flag. It is not for local federal officials such as yourself who lack access to all relevant information, oh my gosh, to question these judgments within the Justice Department's chain of command. Oh my gosh. All right. Oh, this is so bad. This is really bad, everybody. This is really bad. Oh, this is crazy. Oh my goodness gracious. All right. You claimed oh my gosh, everybody. Sorry, I need to drink a sip of tea here. All right. You claim to find my reference to Victor Bout to be alarming, but you have missed the fundamental point. I'm not sure she's the one that's missed the point here. Presidents frequently make policy decisions the Justice Department is charged with implementing. In connection with the case against Bout, President Biden made a questionable decision to release the Merchant of Death from prison. Once the decision was made, it was the responsibility of the department and your office to execute it, regardless of anyone's personal views of the policy choice. And a prosecutor from your office filed a motion to assist in effectuating the decision, citing that case. That was your job here and the job of the prosecutors assigned to the case. You have all violated your oaths by failing to do so. In no valid sense do you uphold the Constitution by disobeying direct orders. Oh my God, everybody. Oh my God. This is it. This is it, everybody. This is the moment. This is the language right here. This is the language that is after the Constitution. This is really a lot. When you say bad, do you mean badly? Or, I'm not sure at this point. I'm not sure. I will need to think about this for a little while. Bunker times. Oh my gosh, this is bad. This is really bad. In no valid sense do you uphold the Constitution by disobeying direct orders, implementing the policy of a duly elected president. That's psycho. And anyone romanticizing that behavior does a disservice to the nature of this work and the public's perception of your efforts. All right, we're in psycho land. How do we spell psycho, everybody? Sorry if I spelled it wrong. I don't have spell check. Wow, this is bad. This is really bad. This is a really bad situation. Seriously, this guy he's got to be put back in the cage. Who summoned this guy? All right. Stop chanting, please. He needs to go back. You've also strained, oh my gosh, unsuccessfully to suggest that some kind of quid pro quo arises from my directive. This is false, and you acknowledged previously in writing. As you've acknowledged previously in writing, the Justice Department is charged with keeping people safe across the country. Your office's job is to help keep the city safe, but your actions have endangered it. Wow. Oh my gosh. Wow. Oh, all right. We're going to move forward. We're going to keep moving. Right. Oh my God. Call Congress. Everybody call Congress. Oh my gosh. You need to call Congress because you know, if you can pull her, she can be impeached. This is impeachable to have one of the people that she pulled in as a subordinate to come in and say grand juries are corrupt, essentially, and that you need to follow orders or you're not following the Constitution. These are really big, huge issues. All right, so let's talk about Rule 48. Rule 48, she mentioned in her resignation letter because she said, you know, the court is ultimately the one that decides whether or not to dismiss the case. And if it's not in the public interest, the court will not dismiss the case. So let's see what he has to say about that. More broadly, you are simply incorrect to contend that there's no valid basis to seek dismissal. So this is the part I'm really interested in. I'm so confused. Yeah. More broadly, you're simply incorrect, right? So to contend that there's no valid basis, the contention is a dereliction of your duty here and to advocate zealously on behalf of the United States. The main citation you've offered, U.S. v. This case here, involved a motion based on expense and inconvenience. Sticky notes, thanks. Sorry. Appreciate that. Those issues are not the drivers of this decision, as you know. Moreover, as you and your team undoubtedly learned during the research that led you to rely on a 57-year-old district court case. What? No, hold on a minute. Now he's saying, are we not supposed to rely on precedent? Like, dude, that's just like lawyering. What led you to rely on a 57-year-old district court case? What? The government may elect to eschew or discontinue prosecutions for any number of reasons. Rarely will the judiciary overrule the executive branch's exercise of these prosecutorial decisions unless it is not in the best interest of society. Wow. Dude, you need to read more than one sentence. In other words, the Attorney General has a virtually absolute right. Oh my gosh. Are we back into the absolute immunity thing here? You people, to dismiss the case, citing Salem. Any judicial discretion conferred by Rule 48A is severely cabined and likely limited to instances of bad faith. This could be, let me tell you something about bad faith. Pulling in unsubstantiated political rumors with no evidence, no facts, and no legal justification. That is what we would call bad faith in the legal world. But he probably doesn't know that. The substantive reach of Rule 48 appears to be effectively curtailed by the fact that even if the judge denies the motion to dismiss, there seems to be no way to compel the prosecutor to proceed. Accordingly, any concerns that you and your office had about the prospects of a Rule 48 motion were not valid basis for insubordination. Were not valid. So he's saying that's not good enough for you to not follow my order. Like, this isn't the military, man. She can resign. If she doesn't want to do something or she finds something unethical and she wants to resign, she can do that. And he's in here saying, no, it doesn't matter what you think. You follow orders. When I give you an order, you follow it. And if you don't, then we're going to investigate you and your team. So this is a follow order situation that is like out of control. Additional issues to be addressed. All right, let's see it. So we're on the final page. All right. Finally, and to be clear, while I elected to address two particular dispositive concerns in my February 10th memorandum, I have many other concerns about this case. Seriously, Stephen Miller, maybe they wrote it together. Or maybe he is the one that actually is Stephen Miller's, like, emperor, you know? Who knows? The case turns on factual and legal theories that are, at best, extremely aggressive. I thought he hadn't read it. For example, the district court explained that it's not inconceivable that the Second Circuit or Supreme Court might, at some point in the future, hold that an official act as defined in McDonnell is necessary under Section 666, at least as to government actors. So now we're back in that immunity language with that official act crap. The district court also acknowledged that there is some force to Mayor Adams's challenge to the office's quo theories in the case. The things of value in this case are campaign contributions, which required heightened proof under McCormick, as the office knows from the challenges you encountered in connection with the decision to dismiss in the Benjamin case. There is also questionable behavior reflected in certain of the prosecution team's decisions, which will be addressed in the forthcoming investigations. Witnesses in the case do not appear to have been treated in a manner that's inconsistent or that is consistent with your claims about the seriousness of your... Wow, this guy is a nut job. This fella's crazy. Allegations against Mayor Williams. It's my understanding that around the time the changes were filed, the prosecution team made representations to defense counsel regarding Mayor Adams' status in the investigation that are inconsistent with the Justice Manual's definition of target and subject. I think this is when she was saying his attorney was saying, you know, make this disappear and we'll help you with your immigration stuff. In the same period, despite having already started to draft a prosecution memo proposing to change Mayor Adams, the prosecution team invited Mayor Adams to a proffer, in effect baiting him to make unprotected statements after the lying prosecutors had already decided to try to move forward with the case. Since when do prosecutors cheerlead for defendants? When has that ever been a thing? Because this Bove guy is a prosecutor and he is saying this, and this for the defense. And, you know, he's a defense attorney such that he is when he's, you know, out there with Trump. So he's seeing this from a defense point of view. But on the other hand, that's not his job. Like oh my gosh, his job is to represent the people of the United States of America. I take no pleasure in imposing these measures. Not true, weirdo. Initiating investigations and requiring personnel from the Justice Department to come to your district to do work that your team should have done was required to do so. In this instance, however, that is what's necessary to continue the process of reconciliation and restoration. Oh my God, creepy words, man. Of the Department of Justice's core values, as the Attorney General explained on February 5th of 2025. This is, that's 1933 language. This is, wow. Wow, everybody. Wow, wow, wow. Wow. Whoa, this one's really bad. All right. We're going to put this aside real quick because I want to get through the last couple pieces here, everyone. Oh, my gosh. It's hard to make it through because... this is so awful, but we will make it through. So this then is the resignation letter. Confederacy language. Absolutely. Yeah, I would agree with that. I think that Confederacy language. Absolutely. Yeah, I would agree with that. I think that's very accurate. Confederacy language. All right. So we have the DOJ Adams situation. And then this is the resignation. I'm sorry, that's my cat. She's chasing something. A resignation of the Scotton. Oh, I hope I say his name right. So Scotton here. He was one of the two people that Bove put out in his letter. What type of an attorney are you? I'm kind of an everything attorney, but have primarily worked in constitutional law and criminal law, evidence, those kinds of areas. Some administrative law as well. So... Civil War era language. Yes. See, and sometimes what happens is these guys get lazy and their egos are so huge. They don't take the time necessary to proofread their stuff. And because they keep spouting these kinds of phrases to each other so much, they don't even see it when it's in their stuff that they're showing to the public. So it's like, you know, they would know this language isn't appropriate, but they don't see it anymore because it's just so ingrained into what they're trying to do. And I think that has a lot, has happened a lot here. Do we have hope? Absolutely, we've got hope. We have this amazing attorney here who said, y'all are nuts, and I'm walking away. And there are like 6 other ones. And this one here did. This is the hope right here. All right, here we go. Email, USV Adams, Mr. Bove. Again, now that fella is something wrong with him. I have received correspondence indicating that I refused your order to move to dismiss the indictment against Eric Adams without prejudice, subject to certain conditions, including the express possibility of reinstatement of the indictment. So that's really the key, is to hang this. If he had said without prejudice, right? So if he had said with prejudice, so it could never be filed again, I think this would have taken a different turn. They would have been unhappy about it, but it would have taken a different turn. It's this idea that at any time they could bring this criminal case against him. That is that quid pro quo issue. They're like, you're holding this over his head. Either take it or let it go. Subject to certain conditions, including the express possibility of reinstatement of the indictment. So that's really a key here. That is not exactly correct. The U.S. Attorney, Danielle Sassoon, never asked me to file such a motion, and I therefore never had an opportunity to refuse. But I am entirely in agreement with her decision not to do so, for the reasons stated in her February 12th letter to the Attorney General. In short, the first justification of the motion that Damian Williams' role in the case somehow tainted a valid indictment supported by ample evidence and pursued under 4 different U.S. attorneys is so weak as to be transparently pretextual. And if it's pretextual, then it means it's not legal. The second justification's worse. No system of ordered liberty can allow the government to use the carrot of dismissing charges or the stick of threatening to bring them again to induce an elected official to support its policy objectives. So right here, everybody, this is it. This is the language. This is the language saying, this is bonkers, and I'm not going to follow your order because your order is out of line. There is a tradition in public service of resigning in a last-ditch effort to head off a serious mistake. Some will view the mistake you are committing here in the light of their generally negative views of the new administration. I do not share those views. I can even understand how a chief executive whose background is in business and politics might see the contemplated dismissal with leverage as good. And that's part of what I'm thinking too, is that this attorney, this Bove guy is like, I'm not doing anything wrong. I'm not doing anything wrong. It's no big deal. If distasteful deal, but any assistant U.S. attorney would know that our laws and tradition do not allow using the prosecutorial power to influence other citizens, much less elected officials, which is quite a bit of what the argument was in Trump's cases, right? They kept saying there was a weaponization, right? And Biden was coming after him. But in reality, that just wasn't happening. So he's doing what he had said was being done to Trump, of course, which, again, we go round and round and round on that. Much less elected officials in this way. If no lawyer within earshot of the president is willing to give him that advice, then I expect you will eventually find someone who is enough of a fool or enough of a coward to file your motion. But it was never going to be me. Please consider this my resignation. It's been an honor to serve as a prosecutor in the Southern District of New York. Signed Hagen Scott. Wow. Oh my gosh. Oh my gosh. Whoa, everybody. And then here we go. Here's, as we wrap up tonight's live, that's, like the song that never ends. We have people coming in from other countries. We have, oh my gosh. All right, here we go. February 14th, we have a dismissal that was filed in New York. Here we go. U.S. via Eric Adams. The United States respectfully submits this motion seeking dismissal without prejudice on the charges of this case. So I'm not going to put a sticky note up here because we've got what it is right here. With leave of court pursuant to Rule 48A of the Federal Rules of Criminal Procedure. Down here, the undersigned attorneys from the Department of Justice have replaced the AUSAs from the U.S. Attorney's Office, oh my gosh, for Southern District of New York, as counsel of record for this case. Let me tell you what's wrong here. I mean, there's a lot of things that are wrong. Let me tell you, though, this isn't correct. This isn't correct. So the undersigned attorneys for the Department of Justice came in. So they couldn't find Coward in the AUSA. So in this office, the U.S. Attorney's Office, they couldn't find a Coward to do it. So what they did, you need to stop stalking me, sir, or there's going to be a problem here. You can turn off. Okay, I've turned it off like 5 times. The dude was back, everybody. All right, done, back in it. The problem here is that they have just said, well, we're replacing it. But if you are counsel of record, you have to file. You have to file saying, I am now counsel, and or the other people have to be officially removed. So you've got to go through the court. You can't just come in and say, I got this case now. So there's a couple of different ways this could go. It seems like this might be an exigent circumstance where they're like, well, we cleaned out the whole office, so we're coming in. But this is really questionable behavior, and any criminal attorney would know that. All right, next up, back here we go. Reasoning that the government may elect to eschew or discontinue prosecutions for any of a number of reasons, including based on announcements related to general policy, citing the Fokker serves case, decisions to dismiss pending criminal charges, no less than decisions to initiate charges and to identify which charges to bring, lie squarely within the knowledge of the prosecutorial discretion. And we're citing the Amos case here. Government's view of the public interest does not clearly fall within the types of reasons found to provide legitimate grounds to deny the government Rule 48A motion to dismiss. So basically they're saying, we can dismiss for whatever reason we want. Is that both under a burner count? That's so funny. I would think so, but I was talking to him. I mean, it was like he's in another country or he's got scenery behind him. All right. So they're already putting her argument here into this first paragraph. Through counsel, defendant Eric Adams has consented in writing to this motion and agreed he's not a prevailing party for purposes of the Hyde Amendment. Number 3, on September 24th of 2024, Adams was charged in a 5-count indictment. 4, the acting deputy attorney general has determined. All right. So attorney general, right, appointed by the president, approved by the Senate, and can be impeached. So this is the Bondy lady. And then this is that nut job that says that grand juries are corrupt, and he's like the law of the land when it comes to weaponization. That guy has this position in the Department of Justice. Like, that's a lot. He shouldn't be that high up. Oh my gosh. Sorry, everybody. I calm down. Deep breaths. All right, here we go. The acting deputy attorney general has determined, pursuant to an authorization by the attorney general, that dismissal is necessary and appropriate, and has directed the same based on the unique facts and circumstances of this case. In connection with that determination and directive, the acting deputy attorney general concluded a dismissal is necessary because of the appearance of impropriety and risks of interference with the 2025 elections in New York City, which implicate Executive Order 14147. Your executive order is not going to save your ass, dude. The acting deputy attorney general reached that conclusion based on, among other things, review of a website. So he looked up the prior prosecutor's website. He's using that as his evidence, maintained by a former U.S. attorney for the Southern District of New York, and an op-ed, an opinion piece by a prior prosecutor. Oh my gosh. Weak evidence, dude. Oh my goodness. Oh my gosh. And number 6, in connection with that determination and directive, the acting deputy attorney general also concluded that, I think it's interesting. Let's pause for a moment. In every single one of these, whomever's writing this is saying that this is both. So they're saying the acting attorney general made this determination. The acting attorney general concluded dismissal. The acting attorney general concluded continuing was bad. Have you noticed that? So in each one of these pieces. So again, when we get to the end and we see who the coward was, I think it'll be interesting because it's both. Everyone is saying it's both. Poses unacceptable threats to public safety, national security, related federal immigration initiatives and policies. The acting attorney general, again, deputy attorney general, reached that conclusion after learning, among other things, what's that? Is that like, How do you know how a car works? Well, yes, after learning about it on, my video game. Among other things, that as a result of these proceedings, Adams has been denied access to sensitive information that the acting deputy attorney general believes is necessary for Adams to govern and help protect the city. Wow, this sensitive information, like all of this he's basically trying to push the judge out because all of this stuff could be handled through the courts, and that's what it should be. Here we go. Number 7. Accordingly, the United States respectfully requests on consent that the court enter an order of nolle prosequi, pursuant to Rule 48A. So again, dismissal without prejudice with respect to all the charges in the indictment. And this was dated today. Now let's see, who are the cowards, everyone? We're looking for cowards. Antoinette Bacon, supervisory official, criminal division, and Edward Sullivan. All right, so we have our 2 cowards here. 2 cowards. All right. Here's our 2 cowards. And then look at what we have down here. Look what we have here. We have, based on the foregoing, I hereby direct with leave of this court that an order without prejudice be filed as to the defendant here. And it's signed. So this is really interesting. He signed it. This, inner circle bad guy signed it. And then down here, all they put in for the dismissal, he just added that on. So this is what they're just saying, hey, can you just sign this? This would be the rubber stamp that people are talking about, where he's like, okay, fine, dismissed. Like, that's not going to happen, everybody. That's not going to happen. So we got 2 cowards. This is questionable here. This is really questionable. I'm wondering what's going on. And then this, demon character that's been summoned. All right, everybody, here's a Q&A. Let's do a brief Q&A. Yeah, try to figure out what's happening. No, it's not been dismissed. This is a motion to dismiss. We have a motion in play here. So after a motion is filed, then, the defense gets to file something, but they consented. So it's basically a joint motion. So then the court will look at it and make a decision. Usually this situation, they're going to set it for a hearing. I have no doubt. They're going to set it for a hearing, and they're going to need the government here to come in and justify the reasons for requesting a dismissal when there weren't any valid grounds. And again, we have this public interest level. That's a minimal level, a minimal burden here, where the judge can say, no, I can't dismiss it. I can't dismiss this case. It goes against public interest for it. And then the question becomes after that, like, well, who's going to prosecute it? Because the Department of Justice said they want it kicked out. So who's going to prosecute it? And then that's where we get into the very interesting world of pulling in some kind of a special prosecutor here. Right. It's not dismissed. Can the judge request to hear from the lawyers? Yes. Yes. He certainly can. So we're not in a situation where we have a jury here. We're in a hearing situation. That judge can ask, what the heck's going on? I need you guys to brief this. The judge can also put out other requests as well. So the judge has a lot of discretion in this situation. What about undermining the jury? That's a huge issue, Jack. You're absolutely right. This isn't just, like, oh, we're going to be jerks today and file. No, this was grand jury came back with probable cause. Do we have proof beyond a reasonable doubt? No, but we don't need that for an indictment. We need probable cause. And they came in and they said, we have probable cause. And she came in on her resignation letter and said, not only do we have probable cause, we actually have enough evidence for beyond a reasonable doubt here. So we have way more than what we need and can take it all the way to the jury. Do you think the governor will fire Adams? It's possible. Is the judge going to see all these documents? I have no doubt. That this stuff will all be put forward. Mm-hmm. Can we, the people, ask for all of this to be looked into? It is being looked into. Bondi will never be impeached because Elon's chokehold threatens the GOP of the House and the Senate. Well, I never say never, all right? Never say never because just, yeah, we're in a weird situation here. And I use the example of Chuck Grassley. That dude, he's already had some questions about how our procedures are being done here. All right, so there's some questions. Yeah, there's some questions. This has been going for years, this investigation. And, with Adams going to the inauguration and, making the deals, going to the Department of Justice without the prosecuting attorney there, like anytime you've got a case that's been indicted, both parties need to be present. You shouldn't be ex parteing with the boss of the prosecutor. And that's essentially what was happening here. So you can't just do that. Do we know the judge is rubber stamping? No. I don't believe the judge will rubber stamp this. Some judges, they just see a motion to dismiss from the party that brought the case, and they'll just be like, fine, dismiss it. But this case, no way. This is complicated. Kind and generous to do this. I'm going, Leslie, I'm happy to help. And I will be here as much as I possibly can be, either here or over on the tube of you. So I'm not going anywhere. We got to work through this ex parte. Well, yeah, exactly. So there's ethics violations all over the place. And this Bove guy's wrote out his confession, wrote out his ethics violations in his letter that he wrote. So haven't stopped here before. Well, welcome. Thanks for spending. Yeah, of course. Valentine's Day. Well, my husband didn't work today. So yeah, the sigh. Oh my gosh. This is it, everybody. Everyone's been asking me, when do we go to the bunker? The ongoing joke is, I'll let you know when we're at a point where our democracy is so broken that it's bunker time. We need to go underground for a few years. We're not there yet, everybody. And the reason we're not there yet is because we have these amazing people, Hagen Scotton and I'm going to say her name wrong, Miss Sassoon. They stepped up here. They stepped up and they said, you know what? There are rules, there are ethics, and those are more important than your view on what's weaponizing here. We've got a Democratic mayor in New York City. He's Democrat, right? And mayor in New York City, we got corruption. Meanwhile, we have Republican attorney generals she's clerked under Scalia. Are you kidding me? It doesn't get more conservative than Scalia. And she's come in part of the Federalist Society. I mean, my goodness gracious. And she's the one that's saying, wow, this is a step too far. Like, that's major. That's a huge issue. Not only that, but the scuttlebutt, everyone, in the legal community, we see what's happening here. Many prosecutors, and I'd said this before too, myself included as a prosecutor, many times the reason why we move to a different position is because we get asked to do something that's unethical. And we say, no, we're not going to do that. And our bosses push us to do it, whomever was elected. And if you're an assistant DA, you got to do what your boss tells you to do. And so what you do is you just turn your card in. You're like, I'm not doing it. This is not something I'm going to do. It goes against my ethics. And that's why I moved jurisdictions. My very first position as a prosecutor, I'd been there a couple of years. And my boss said multiple things. But one of the things he said, because I wanted to call a judge out on some very, very bad behavior. And he said, don't anger the judge. We can't call the judge out on anything. You just go with it. And I was like, I'm out. And that's enough. And this is what happens. And this is what I try to tell people when it comes to the criminal justice system is that, and people who've taken an oath to the Constitution, we take it seriously. The only people that don't take that oath seriously are the cowards and are the, nut jobs here that are, the villains in the movie. So you have to have morals and ethics in order to do the job. This is such a huge responsibility. You're not representing a person when you're a prosecutor. You're representing the people of your jurisdiction. So when you stand up, you say, I'm representing the people for the state of whatever. I'm representing people for the county of whatever. And in this case, she's standing up in front of a judge and she's saying, I'm representing the people of the United States of America in the Southern District of New York. And when she says that to a judge, that's a huge responsibility. And so for her to come in and say, wow, I can't do it, that's huge. That's a huge moment. We've just got to recognize that, we're not just going to get into line and fall down. And that's, one of the key checks in the legal community. We see a lot of bad ones. We're seeing bad ones here right now, actually, with Mr. Bovee. But on the flip side of that, you're going to see a dozen others that are good, that we do respect our oath. We do respect the Constitution. And, that's why we got into this business. It doesn't matter what kind of lawyer. You can be a patent attorney. You still take an oath to the Constitution when you get your license. Every attorney has to take that oath. And, you just have to understand that someone who doesn't respect their oath, I think one of the best ways to quote Justice Sotomayor with Mr. Trump is he's an oath breaker. He broke his oath. And so she refers to him as, the oath breaker. Oh my gosh, in the Anderson case, I just love that. And it's true. He's an oath breaker and people around him can be oath breakers. But in reality, there's more of us that uphold our ethics and our oaths than there are people who don't. So it's just sheer numbers. It's just numbers. Yeah, so why are the circuits any of the circuits, they can be disasters, right? And, if nothing else, the positive here is and I've said this before, is that we're cleaning out the rats. So the lights are on, there's no more hiding. The problems, they're talking about quid pro quo, but to be quite frank with everybody, I'm going to blow your mind, but there's quid pro quo going on all the stinking time with prosecutors and defendants. When a prosecutor is in a position where their power can't be checked, that happens. It just happens until another attorney comes into play that says, you're unethical, you need to go. And a lot of times that attorney comes from the Office of Ethics, the ethics office. And they're like, dude, you're out of line. You're done. And so they don't get caught. But now, everybody gets to see it. Everybody's seeing what's happening here. And it's at such a huge scale that it's look, we've got rats. I'm not saying we don't. The legal system absolutely does. But now it's time, take a look and start gathering them up and getting them off the ship. So that's my view of it. You think there's a possibility of impeachment? Yes. Ninth gets way too much flack. Circuit is it's huge. The Ninth Circuit is huge. We could split those up a little bit. I think that would be okay. So they keep attacking it and trying to discredit it all. I know, which is weird because the more you discredit it, the less power they actually have, right? So if you are, trying to get rid of the Constitution, the Constitution is what gave you your power, dude. So, step back. Let them walk the plank. So I would say this is huge, everybody. This is a huge moment. This is what we have been, the shoe is dropped here with this case. And I know we've got the federal funding issue. We've got Medicaid. We've got so many issues going on. We're overwhelmed. We're flooded. This is the one. This is the moment. This is, for me, this is the third strike where if it is not properly addressed, that's it. We're, yeah. I'll tell, we ride at dawn, everyone. That's what I'm trying to say here. Should have impeachment, should have resignation letters from the people involved. If Bondi was a normal human being and an ethical attorney, which I don't know, she would be taking one for the team and bringing Bove down with her. Her resignation should have already been in after reading the letter that he wrote. But it just shows that, the ethics at a lot of the people at the top are just not there. This is it. Yeah, this is it. This is it. on the checks and balances, not checking and balancing. It's starting. They're starting right now. Protest tomorrow at noon. Absolutely. Will Congress call a Congress? And this one's easy. This one is, does the Department of Justice need to follow the Constitution or not? It's just that simple. Not properly addressed. We show, right. Are we going to get another? Yeah, it's up to Congress. And you should ask them. Ask them. Like, hey, Grassley, hey, dude, what the H? What the H is going on? So this is just the beginning. And again, anything in the legal system, everybody, it works slow. We work very slow. But you can't, I cannot even express the level of how upset the attorneys in the United States are right at this moment. The ones paying attention, and in the criminal world, the prosecutors and defense attorneys, like, you want to unite those two sides that hate each other. This is it. You pull some crap like this and it will unite us, because this is just overwhelmingly out of line and it goes against our ethics. It just does. So I support the attorneys who quit. Some people say, well, if you quit, then they can just put another bad one in. And, you're right. But on the other hand, if they had gone forward, they would have violated their own ethics. And the fact that they didn't means, again, we are in a moment in time here where these people have more integrity than the leaders. And so they're walking forward with that. So, truth will rise up. Absolutely. Can we file bar complaints? Absolutely bar complaints. I don't know where he's licensed out of. I'm assuming New York, based off of, him getting slammed down so many times in court in New York for being a dumbass. I'm going to have to go back and read those transcripts. Yeah, I went through those transcripts in New York. And this Bovee guy, the judge was like, I'm sorry, what? You should know this. You should know better than to do this. I'm going to have to go look at that. I think it's New York, but it could be DC. But anyway, yeah. So you could absolutely write a letter and be like, dude, I don't think it's right. And include his, this is available online, everybody. And one of the things that could be incredibly helpful for your elected officials is if you were to go online, print this out and actually put it in an envelope and send it in and be like, is this okay? Because I don't think this is okay. Give it to them. Here's the receipt, man. Send it into the bar. Here is the receipt. Take a look at that. So yes, so here's the recap. We've got Eric Adams, been investigated for a very long time in New York for corruption. Grand jury came in and indicted him on 5 counts. The charging prosecutor actually resigned from the case, and a new prosecutor came in. This had been going on for quite a period of time. So Adams got buddy with Trump. He went to the inauguration, went to Mar-a-Lago, hung out with him at some, UFC stuff. Although those things are really loud, but I digress. Anyway, so there was this understanding. He also, by himself with his attorney, went to the DOJ twice without the other U.S. attorneys involved and was talking to him, blah, blah, blah. So then Emil came out here, Mr. Bove came out and said, I'm not looking to read in the case. I don't know anything about the case. You need to dismiss it. And the attorney came back and said, that's unethical. I'm not going to do that. I'm going to resign if you don't set up a meeting for us to talk. So then he wrote back and said, fine, I'll accept this as your resignation. And now I'm going to investigate you and your team because of dereliction of duty, because you do what I tell you to do, or, then we're going to investigate you. So then that happened. And so then the other guy in the office was like, you can have my resignation too. And anybody that files this motion to dismiss is a coward. One of my favorite sentences of all time. So a motion to dismiss was filed. It is on file officially, but now it's up to the court to decide whether to set it for a hearing or what they want to do with it. So there you go. There's a 3 minutes 3-minute explanation. Oh, yeah, yeah. And this is quid pro quo. I mean, you're not going to get, I mean, she was already putting in her letter, like, Bove told my person to shred their notes. And clearly in the meeting, this was mentioned multiple times. So, I mean, there's just so much. There's so many facts. And, if Bove could have pulled his head out and recognized the standards we actually use in court, in the process, he could have made a case. He could have said, I've got reasons 1, 2, 3, 4, 5. I want the case dismissed, and set out those legal reasons. He could have done that. He could have said that there, some kind of abuse of power. There was some kind of a search and seizure problem, whatever. But he didn't. He's so full of himself and so caught in the spin of you bad people that he was like, whatever I say is correct, and you all need to follow me and bow down. And if you don't, then bad things are going to happen. Chanters, stop chanting. That's right. That's what I'm saying. Stop summoning him. And Miller, while you're at it, right? They need to go back to the dark place they came from. Yeah. I mean, again, in Bove's piece, he's like, well, the grand jury is, I mean, we got red flags all over the place here. We've got a psycho. We've got 1933 here. There's red flags everywhere. It's a mess. So it's a problem. And he wrote it all down, which is nice. D-Bar, yeah. I mean, we could definitely have that. Calling Grassley. Yeah, I mean, the reason I bring Grassley up is because he's the ranking member on the Judiciary Committee in the Senate. So that's why I keep bringing him up. You're like, why are you bringing up him? He's a super old dude. He really is. I mean, super old, for whatever that's worth. So, yeah. I think it was always, yes. So I will go ahead, everyone. Oh, my gosh. We've almost hit 2.5 hours. New record. Oh, wait. Oh my gosh, it's 3.5 hours, everybody. Oh my goodness gracious. Oh my gosh. Well, thanks for hanging out with me, everybody. I think it's kind of weird because we had a split in the middle. We had a little Pakistan visit, maybe, or somewhere. I'm not sure. Anyway, thanks for hanging out with me, everybody. I hope this was insightful. This is it, though. This is the one to watch. Article on Off You Go, Deborah. You've been working so hard. Thank you so much for your hard work. I'm always thankful and grateful to you. Trying to be Rupert. I don't know. I'll have to take a look at that. I've been my mind's blown right now. Thank you from Australia. Absolutely. Thanks for coming by. So there's some crazy stuff going on, everyone, but this is the one to watch. So we'll see. Again, this has only been 48 hours. Our legal system does not work that fast. So give it a little bit of time. This is going to cook, and we're going to see what happens here. So take care. Yes, I will put this up on the tube of you. It's going to take some time because it's so long. But take care, everyone. Have a great night, and I will be back again as soon as I can. And, of course, I'm over on my tube of you as well.